Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this set of videos, we're talking about 245I and all the different provisions of 245I. Now, one requirement to be under 245I is that the original submission of the application had to be a bona fide application. Now, what does that mean? Um, There were, just so you know, back in April 30th, 2001, and then the first enactment on January 14th, 1998, there were thousands and thousands of petitions that were being filed at that time to try to get people who were here illegally basically a chance to be able to ultimately adjust status. Well, if it turns out that the original application that was filed is not bona fide, you're not under 245I. So some blatant examples, let's say that a petition is filed based upon being married to a U.S. citizen and there is no U.S. citizen spouse and you made up that person, that of course would not be a bona fide application. And bona fide means real and valid and approvable. It doesn't mean it ultimately needs to actually be approved because that's a different matter, but it needs to be approvable. So, for example, if there were an employment-based petition and the employment or the employer either didn't exist or didn't really offer the job, then it's not bona fide. So, for example, if everything's legitimate, except the employer said, "Well, here I'll help you out. I'll help you file this, but I really have no intentions of ever hiring you." That is not a bona fide application. That's also fraud. So you need to make sure that when you submit the adjustment application, that there's also some indication in the application that the original 245I submission was bona fide. Okay, more in the coming videos.